So, thank you, ladies and gentlemen, and welcome. It's a pleasure to be here. I am Marton Csirik from Hungary on behalf of Georg Pintz Partners Patent Office. My presentation today will be about community trademarks, CTMs, as they are abbreviated. First, I will talk about the advantages of filing a direct CTM as an outside EU company or a natural person. Then I will give some practical advices that you should keep in mind during the registration process. And then I will point your attention to two of our services that can be very useful if you or your client owns a community trademark. So, as the other speakers have already mentioned it, the main aim of the European Union was to create a unified single market, which has basically a very, very enormous economic potential, includes 28 countries, 4.4 million square meters, more than 5 million people, and produces 30% of the world's nominal gross product, which is quite enormous. So in Ukraine, if you think about mass export, or your client's company thinks about mass export, you should keep in mind the potential of the European market. Now, the basic rules of the CTM are included in this 207/2009 Council regulation on the community trademark. It is not so different from other national applications and not so different from the Ukrainian one. I have checked. Sign can become a trademark that can be represented graphically, and there are some new aspects in that area, of course. Colors and three-dimensional trademarks, which are similar to designs, can also be registered. There are absolute and relative grounds for refusal. Absolute grounds mean that the sign cannot be registered under any circumstances. The relative ground means that the obstacle is only because there is an existing earlier trademark, which is similar or identical to the later one. The scope of protection includes exclusive rights for the owners of producing, distributing, selling, exporting, importing, etc. And the duration of the CTM is similar to other countries' practice. It lasts for 10 years. Absolute grounds of refusal can be being deceptive or being non-distinctive. It cannot distinguish the goods or services from other companies. Or it contains forbidden elements, for example, state names or the Red Cross, etc. Now, it's a picture that represents the two options you have when you are applying for CTM, because the two possibilities are to file it directly, or you can also use the Madrid Protocol, which means that you have a Ukrainian trademark and you can designate it to Spain, to Hungary, to France, but also you can designate it to a whole CTM. It's similar to the European patent, can be designated to national ones and unitary patent. It's similar. You have to decide carefully. The thing is that non-European Union entities are a little bit afraid of direct CTM application. I don't really know why, but I think one reason can be that in front of OHIM, Alicante, you must have a professional representative to to represent you there. Meanwhile, WIPO designation can be started from here, Ukraine, and maybe the clients here don't want to directly look for a European representative, so they start a procedure here. But this is wrong, because direct CTM filing has three major advantages compared to the WIPO system, as it's written here. First of all, the time frame. The direct filing can result in an obtained community trademark within 6 or 7 months, provided there is no opposition, of course. And this fast tracking, it is very, very new. It starts next Monday, actually. It means that it will be faster, the whole procedure. It's free of charge, but you have to meet several criteria. The two most important things is that you have to pay the official fee immediately, but you have to pay it anyway, so it's not a big problem. And the other one is that you have to name the list of goods and services from the harmonized OHIM database. This is a list of expressions that are accepted by the European Harmonization Office. And if you meet those two criteria, you can obtain a community trademark within 5 or maybe even 4 months. Meanwhile, the WIPO registration takes a little bit less than 18 months, so it's, the direct filing is way more advantageous. The second one, this central attack means a great risk regarding the Madrid Protocol. It means that within 5 years from the original registration, the trademark is cancelled. All the other trademarks based on this original one are also cancelled within 5 years. So, needless to say that this is an unnecessary risk, and there is no reason to take it. Meanwhile, if you file directly a community trademark and it is cancelled for whatever reason, it can be separated into national trademarks in which the trademarks meet the criteria of that state. So not the whole trademark is lost, but it can be saved, and some damage control is possible. And also the costs, very important factor to consider. Direct CTM, 1,090 euro, means that it includes 900 euro official fee, and the remaining is the attorney's fee, which can be, of course, more expensive than this. This is our price rate, actually. Meanwhile, if you take the WIPO way to obtain a CTM based on a Ukrainian trademark, for example, only the official fee is about 1,500 euro. And plus you have to also pay for the professional attorney's work, so it's maybe 2 times expensive. Now, okay, let's suppose that you have convinced your client that he or she should file a CTM directly. What should you do when you prepare for that? CTMs have some significant advantages, as I said, but the risks are also bigger than in case of a national trademark, because absolute and relative grounds for refusal stand with regards to all national member states and all earlier community trademarks. So when you search, you should look for these community trademarks, national trademarks, company names, domain names, and even unregistered rights within all 28 countries can be a ground for refusal. So you should absolutely make a thorough search. What are the methods for that? There is a so-called TM view. I don't know if you know about it. It's an interconnected database, and you can reach all national trademark register, also the European trademark register. So use TM view for registered names, but Google, who is your best friend of course, can help you find the unregistered rights, which are like unregistered designs maybe, or other things that can be a possible obstacle. Okay, these were the relative grounds of refusal with regards to all member states, but also the absolute grounds of refusal stand. CTM cannot be non-distinctive or descriptive in any of the 24 official languages, and even the 3 semi-official languages, Catalonian, Basque, and Galician. There was a case where clients tried to register the name Espetek, and it meant something in Catalonian, and they couldn't register it. So you have to be careful before filing. Now, as I mentioned before, non-EU legal and natural persons must have a professional representative. They must appoint one. If they don't have a domicile or a principal place of business, the only thing that you can do is to start the registration. You can start the process on your own, but later you must choose a professional representative from inside the European Union. Okay, you have appointed your professional representative, you go for the CTM, and now you are at the point of choosing the list of goods and services. Some years ago, it was until 2012, there was a divergent practice between the national offices and OHIM, and the problem was the following. If somebody applied for a trademark and indicated, for example, the 5th class of the NICE classification, some offices thought that it meant all the goods in that class, and other offices thought that those mean only the specific goods indicated in the headings. So it caused some distractions. And since the IP translator case, you have to expressly indicate in your application whether you mean the whole class which you indicated or only those goods. And if you don't indicate this, only the narrower interpretation will emerge, so you have a narrower list of goods. But the problem also can be solved, because if you use the fast tracking, which I mentioned, you have to use this harmonized OHIM database, and you will have no problem indicating the goods and services. Now, you applied, the opposition period opens up, which can be based on relative grounds of refusal, and it is, for example, different from the Hungarian one. That's why I am talking about it. That bad faith application cannot be referred to in an opposition period, only after the trademark is registered in a separate cancellation process. What is bad faith? There is no exact definition for that, but the European Court of Justice gave some guidelines. For example, what my colleague said, that applying for a well-known trademark in another country, it's a typical act of bad faith. Or another thing can be if your trademark is cancelled for non-use and you apply for the same mark, but you don't intend to use it again just to maintain the protection, it is also constitutes bad faith. And yeah, there was the Lind case. It was between a Swiss and an Austrian company. This gave the most basic guideline. This case, the European Court of Justice claimed that all circumstances must be taken into consideration in order to determine whether the applicant acted in bad faith. But three elements are crucial. It is whether the applicant knew or should have known that the other party used the sign, whether his intention was to prevent the other party from using the sign, and the third one is how well known is the trademark, how strong protection it has acquired. One practical advice during the application process: you can also register designs for trademarks if you meet the specific criteria for that. For example, Toblerone, this form, this shape, is registered as a community trademark. It is really useful because since it is a trademark, the protection can be prolonged infinite times, and it can be maintained for as long as you want. There are three special grounds for refusal. If the trademark is only a result of the nature of the goods, or it is necessary to obtain a technical result, or the form gives the substantial value to the goods, then it cannot be registered as a three-dimensional community trademark, but otherwise it's okay. However, the European Court of Justice has a very strict practice about it. These are the three most relevant cases in this area. If you want, you can study them, but now I won't go into the details. Okay, so now I talked about the advantages of possible direct CTM instead of WIPO designation, and now I will show you that it's really easy to file it. This is the www.trademark.eu. It's kind of easy to remember, I think. Here you can, okay, this is a 6-step procedure, very, very easy. You give your name, your company name, you upload the image, you give the list of goods, you finalize it, and you pay, and that's it. And it takes about like 20 minutes maximum. I will show you the other parts. Okay, for example, this is the first site. You have to give your data, nothing complicated. Okay, next procedure, the trademark. You can write your text if it's a bird trademark, or upload the picture, and it will, yeah, it takes only 20 minutes. It is handled by our firm, Georg Pintz Partners. We handle hundreds of CTM cases each year, so trust us and file your direct CTM application at trademark.eu. And now, this was one of our services I wanted to mention, and there is another one, and I will play a video for that if you don't mind.
Lock up counterfeiters. In 2013, fake articles confiscated by customs officers at borders of the European Union exceeded $1 billion in value. However, this is only the tip of the iceberg. Today, trademark infringement is mostly committed on the internet. If you have a successful product or service, counterfeits can occur everywhere. Since customers might believe that fake articles of bad quality were your products, the harm done can be even more serious than the loss of customers. You can lose revenue, profits, and have your website traffic diverted to someone else's website. At trademark.eu, Georg Pintz Partners LLC offers its newest worldwide unique infringement monitoring service. Infringement monitoring scans through the internet for trademark infringement, including social media, documents, and domains under the new GTLDs. This program also monitors the trademark databases of European member states and the USA. One of the very strengths of the application is that it scans the internet not only for similar or identical word marks, but also for figurative marks by conducting an image-based search as well. Furthermore, the monitoring can be extended to alphabets other than the Latin one, namely Chinese, Russian, Japanese, Thai, Arabic, and Hebrew.
So that was it. I don't know if you understand it completely. So this is a computer program called infringement monitoring, and it can, okay, so it's also a 5-step procedure. You upload the variations. If it's a word mark, then you write it. If it's an image, you upload it. Sorry? Now? I don't know, because maybe, yeah, we can try it actually. Okay, is it, what is it? Okay, in Ukraine? Okay. What was it? V-O? V-I-O. No. Okay. Okay, now you can add the variations. Okay, because maybe there is one letter difference. So what should I write? Let's say V with V. Let's try with V. Okay. V-O-N with N. Okay. Okay, there's 3 more. But okay, let's say it's enough. Okay, next. Okay, we should give the keywords that the trademark is related with, but I don't know what is it. Okay, let's say drink, water. Water, is it? Okay, let's say beverage. Juice. And one more. Soft drink, okay. Yeah. You can add more keywords, but here it's only the trial version. Okay, now you can give some exceptions if the trademark is yours or you have some distributors. You can give the distributor's name in the exceptions, and then it will not indicate it as an infringement. So, but that's not, if you know that somebody is not infringing because he's your partner, then you can add the exception. A and no, I like this. Sorry. Start your E, okay? R. What? L. A. N. Okay. Oh yeah, domain. Okay, it requires a domain name, of course. .com. Okay. Okay, and there you can select from the new generic top-level domains, like, I don't know, you have heard about it, like there, like www.idon'tknow-something.camp, which is an ending, but it's not mandatory. It's an extra feature. Okay, we can go next. And now let's send it to me. Obtain a direct CTM because it's a worthy solution that you can start your process at trademark.eu, and later you can use this infringement monitoring program. Yeah, choose us, and thank you for your kind attention. This is our team. If you have any questions, I am glad to answer. Thank you.